Today I want to walk through some founder legal mistakes that you can easily prevent if you are a founder or starter. Let's start with real world examples here that happen more frequently than you think so that you can be aware of them and consider the ways that you can prevent and fix them. So let's get started. In the first scenario, we have three founders. One founder puts in 80%, and then two others put in 10% each, so 100% total. 6 weeks later, founder A quits. The other two keep working, building product, building up the company for the next few years, and then the company ends up making money. Founder A comes back in and says, hey, here's my 80%. And he ends up walking away with 80% of a company that he did nothing for. The real issue here is that this could have easily been fixed if an operating agreement was put into place that stipulated pretty standard 4-year vesting with a 1-year cliff. This founder had a huge windfall, and the other two were unfortunately left in the dust, so to speak. So a great operating agreement would definitely prevent that. Another example is a founder who emptied the bank account. The founder had a bad weekend in Vegas, had a bad run, said, oh, you know what, I'm going to hit the company account, I'll win some money back, I'll refund the money, but he doesn't. Then the other founder goes after him to recover the money, but A, it may not be available, he may not have the assets for it, and B, it would take tons of time to address the operating agreement, should address the banking authority and spending approvals. Another example is the silent founder. 3 friends start a business, everyone gets 1/3 ownership. After 2 months, one founder stops attending meetings and contributing. The remaining founders build the company for years while the inactive founder keeps 1/3 of the company. Again, vesting is important. If you don't have vesting provisions in there, they can claim ownership when they haven't put in the work to actually earn the equity, which would be under the operating agreement. Founder mistake number 4, the IP example. This is a very large one. IP includes branding, software, copyright, trademarks, any intellectual property that you own. A founder develops software before the company is formed, and he doesn't assign the IP to the company. Later, the company goes to raise money, and there are issues about who owns the IP, and it will take time to clean that up if it's not done on the front end under the operating agreement and under the IP assignment agreement as well. The other issue that often happens is a company with a 50-50 ownership, and there's a dispute. One wants to raise money, one does not. What happens then? There's no tiebreaker. A good operating agreement would have a provision saying that after a certain amount of time that the founders would seek arbitration or mediation. Otherwise, they'll be deadlocked, and while they're deadlocked, the company is stalled. So again, operating agreement will help you establish the rules under which you can operate the company. A founder mistake is, this is a basic one that I'll just go over because it bears discussion, is just no stipulation on the percentages. There are times where founders just assume there are 4 of us, 25 each. However, one owner could think, oh, my portion of the work is worth 50%, and at best, these other folks are worth 50% divided by 3. However, the other folks are thinking the other way around. All of that ties into profits, losses, distributions under the company. And until those items are figured out, who gets the money and under what percentage is really important, as well as voting. All of this is to say that founders can solve so many humongous problems within the company, as well as when they're growing, by having a very well written operating agreement that establishes all the rules and regulations under which the company can operate with respect to items they can do now and with respect to selling or bringing in other members, etc. Again, set up your LLC with your other founders, have the conversations with the founders, and hammer out an operating agreement with respect to ownership percentages, the duties, who's managing the company, what happens if one person wants to sell their shares. Hammer all of that out early so that you can focus on running your business and making money while all those things are keeping up with you. I hope this was really helpful. If you have any questions, please reach out. I'm happy to discuss.